The following program does not have a normal intro because I was really too busy smoothing other things over to get it done. So, Ori? Good evening, everybody. Welcome to the following program. I'm your host, Joe Neerman, aka Good Logic. I need to stop by telling you about my day. I'm going to tell you about my day. And I remember, you might recall that last night when I was like wrapping up, I was like, I got a motion that it's due tomorrow, and I don't know what's going to be with my schedule tomorrow. I don't know what's going to happen with it. Now, so I was up to like, I don't know, 5 in the morning working on that motion. I knew this was gonna happen. I knew it was gonna happen. Lady Lawgic like walked up. She gives me like clack, 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 clack. And she's like, "What are you doing?" So I said, "A motion due tomorrow." She's like, "Wow, okay, that's weird. that's weird." So, okay, it's a motion summary judgment that I had to file, which is like after discovery is done. So it's like, okay, all the discovery is done now. This case has been going on for years. All discovery is done, and I want to, and now they know what we're saying. I know what they're saying, and now we want to basically explain to the court why it is that we should get summary judgment. So this judge gave me, she told me like a month ago that the deadline for filing your motion is November 30th. So, okay, fine. So I, was working on it this week, and I was like, all right, crunch time. I got to finish this up tonight. And I was really plowing away on it, making great headway, really pleased with the way it was unfolding, developing, and everything coming along really nicely, really, really nicely. And then I was like, I'm passing out. So I go to bed. I wake up to the sound of a lawnmower outside my house. Okay. So there's like really loud. I don't know if it's my own landscapers. I don't know. They come on a schedule. So I hear a lawnmower outside my house. I'm like, oh my gosh, what is that? And a minute later, my phone rings, which I never would have heard it. If not, thank God the lawnmower was there, because I never would have heard it. I've slept through earthquakes, literally slept through earthquakes. So yeah, when I'm out, I am out, like out. Well, which I think is a good thing, by the way. Personally, I think it's a good thing because I think that that's a reflection that I'm making positive use of my sleep time. Like I am really getting into being asleep. Like I'm just like, there's like, there's like sleeping people in a coma, me asleep, and then the dead. I'm basically in that zone between like the dead and the comatose. So anyhow, so who's calling me? It's the clerk of the court on this case that I'm supposed to file a motion on. And she's like, we sent you a notice this morning that the settlement conference. So we're wondering why you're not here. I was like, what? Settlement conference? What? What? What's happening here? What's happening? I don't understand what's happening. So I was like, we weren't told we're coming in for a settlement. I don't remember anything about this. So she's like, well, I sent you the Zoom link this morning. So I'm like, okay. I'm busy finishing up my motion on this case. So she's like, well, you're supposed to be here. So I said, okay, give me 5 minutes. I'll be there. So I pop in there, had some audio issues, which the judge was not happy about. Popped out, popped back in, come back in there. And the judge starts talking about how she wants to talk settlement with us, but just sort of like to have like the sword of Damocles hanging over us. She's like, I want to set down a trial date here. So let's figure out our trial date. And I'm trying to go through my calendar and figure out a trial date. And I'm still like groggy. And I'm trying to go through this. And I said, Your Honor, I just want to mention our deadline for filing. She's like, since no one filed a summary judgment motion, so that's why I want to get this thing done. And I said, Your Honor, our deadline for filing a summary judgment motion is today. So she's like, and we're still planning on filing one. She's like, you wait till the last day? So I was like, that's my deadline. I'm like, I plan on filing it today. She's like, what are you going to file it at 6:00 tonight? And I'm in my brain, I'm like, I'm thinking to myself, oh God, I hope I can finish by 6. I really hope I can finish by 6. That'd be amazing if I could finish by 6. But I was like, I don't think that's the answer she wants from me, because I could technically file it until midnight. Anytime November 30th, you file it, you're good. So I'm like, I don't know. I don't. I'm like, I'm going to treat that question like it's rhetorical. That's a rhetorical question. And I'll have you know, I had it done by 5:30. Only 5:30. I had this thing. I had that sucker completely uploaded. So yeah, but that's a full day work for me, and I got very little sleep. So I'm not like So yeah. So then I was like, when I start working, I'm like, okay, what I want to cover for my show. And I keep thinking to myself, there's something I want to cover. There's something I wanted to cover today. And I was like, I have no clue at all what it was. I was like, there was something I wanted to do today. So I'm like, all right, let me start searching through the news, see what I could find, whatever. And I found this thing on TikTok. And I was like, you know what? This is a really interesting legal issue. I really want to check into this. I want to look at what this is all about. So I start looking at the case, and I start pulling up the whole thing, and I'm like, okay, you know what? This is legally interesting. It's philosophically interesting. It's got the whole First Amendment stuff and stuff like that. I was thinking about talking about this also. I was thinking about this. V Radio. He was texting me today, this evening. Should I use names? I could use names. Tell me, V, can I use names, or should I just say, describe, person? And because I don't want to put anyone. I don't want to, like, Anyhow, okay, fine. I'll in that case, I'll ask them. Okay, I'll do that afterwards. Okay, so and I'm sitting there, and I'm like, okay, let me put a show together. And V Radio is making me nuts. Like, he's making me, like, in this long text back and forth with him. Was like, the whole time he sent me this text of his show idea that he wants me to cover. I was like, I don't really know if I want to do that. I don't know if I really want to do that. Oh my gosh, look at you. See this? God bless you. 10 memberships, Bella. Thank you. That is very nice of you to gift that out like that. I really appreciate that. Thank you. Thank you. I really need that. That was a nice boost. Thank you. I appreciate that. Good for you. The reason I give that, I'm gonna give that a second one of these, because I sort of feel like that's just like generosity, and I appreciate generosity. So thank you. Moral story: cramming isn't just for college; it's true. It's for life. So anyhow, I got it all done. I'm very pleased with the final product. I'm like, you know what? This is a solid summary judgment motion. I think I got a decent shot here on this, even though summary judgment is one of the toughest motions you can possibly win. But I'm like, you know what? I think I got a really decent shot here. I'm pretty pleased with the way things fleshed out here. Okay. So now I'm trying to put together a show, and I come up with this whole, TikTok. I see that there's a court decision in Montana where they're looking at where they passed a law to ban TikTok, and TikTok basically sued the attorney general and said, you can't do that. This is a First Amendment issue. So I was like, okay, this is a really interesting. It's a nice size, not too long, not too short. I was like, I can build a show around this for sure. And I'm starting to put everything together, and then I'm putting together my thumbnail, and it's late, and I'm running late, and I'm like, oh gosh, I hate being behind. I was like, I'll start the show late. Maybe I'll run a little late. We'll sort of figure that. I'll massage that part out. And then all of a sudden, I see like this DeSantis Newsom debate. I'm like, oh my gosh, that's what I wanted to do tonight. I totally would have streamed that. If it was live, I would have totally streamed it. But then I was like I was like, maybe I'll scrap this show, scrap what I'm doing now, and watch that debate. But I was like, I'm gonna get like the last 20 minutes of it. No one is gonna get notifications. No one's gonna know about it. I was like, a good debate is a fun one. So I was like, let me start watching this debate. And from what I saw, DeSantis was he just looked like he's like forcing smile. He looks so wooden. I made a comment here. I was like, he looks like last year's AI. It's just like he looks so inhuman. And Gavin Newsom, who I know is slimy, greasy, like just gross individual who's power hungry, your classic cheesy politician. I'm trying to remember there was, but it's just cheesy politician. There was a movie from a long time ago. Maybe one of you will remember. One of you Gen Xers may remember this. There was a movie from a long time ago where there was a politician who was like, you could take it to the bank, sport. You could take it to the bank. You could take it to the bank. And like, he's later identified. I don't remember if he said ace or sport, or he said you could take it to the bank. This could be two movies I'm glossing together. But I remember him being your classic oily politician, and Gavin Newsom just had the exact same look. If any of you know what it is, I don't know. Anyway, bottom line is this. I'm covering this thing here tonight. Oh, thank you, Mary. I'm going to give you one of these too. Thank you so much, Mary. So bottom line is, yeah, I'm curious if you guys want me to cover it. I put a poll on YouTube asking if you want me to cover it Saturday night. It was hard for me to find it. Like I don't pay for TV. Like I'll pay for the news. I'm not paying for TV. I'm not paying Fox for this. There's no way I'm paying stinking Fox for a penny for this. So I'd have to find it for free because I'm not paying the money. I'm just not. I am not doing that. No. I'd rather pay the New York Times than pay Fox. Truth. I would. But yeah, so I don't want to pay them a penny. In fact, there's a few publications I subscribe to, which I sort of feel like I was asking Robert Gouvet about. He's like, no, by you subscribing to it, you're saving your viewers from watching it, and you just share it with them and give it context. So you have to do it. So I'm like, all right, but I'm not doing it with Fox. I'm just not. So anyway, did you get to watch Biden v. Trump rap? I did get to watch that. I did. I ended up watching a whole epic rap battle thing, like one after another. Like I watched a few of them, like Harry Potter versus Luke Skywalker. That was a pretty solid one, actually. Yeah, they do good work. They make a lot of money doing that. You can tell they make a lot of money doing that. Anyway, let me come back to what V Radio wants me to poll you guys. Okay. I don't know if you gave me an answer. It's my last question. This is what he comes to me with. How am I supposed? There's one thing that you said you don't want me to keep them under my hat. So what am I supposed to do with that, V Radio? Tell me what I should do with that. The part I need to keep under my hat. What should I do with the part I'm supposed to keep under my hat? It's like right here. Oh, okay, fine. That's what you want? Okay, fine. I thought the fact that I had it. Okay, fine. Here's bottom line. Okay, this is the story. Kyle Rittenhouse wrote a book. I don't know if it's published yet. It's not published yet, or whatever. It's like whatever. There's definitely a rough draft that's out there. I actually saw one. So Kyle Rittenhouse wrote a book, and apparently some of his family members, sisters, mother, etc., and maybe other persons in Kenosha or wherever he is from, not happy about the book, very upset with him. So like a week or so ago, V Radio reached out to me saying he plans on streaming them and asking me if I was interested in simulcasting it and helping give them a bigger platform. Which I was sort of like, when do you plan on doing it? And I was like, first let me find out what the timing is and whether it's anything to even consider. So he's like, I'm not sure. Yeah, I'll get back to you. Maybe they'll have Dominic Black there. Whatever. Okay, fine. So that it basically went on a back burner. Now, I was like, so tonight he was pressing me to cover it. And I was like, so what are their issues with the book? And tell me, like basically they think that there's certain things that are not true and that he's kind of been a jerk ever since the trial. Which likely true, because when a kid gets instant celebrity and hasn't been trained for it, hasn't been groomed for it, they tend to become it tends to change them. So, and he's definitely an instant he was an overnight celebrity. So I wouldn't be surprised. But then I'm like, I just feel like I was like, I'm sure he sensed in my text view that I'm like very torn about it. So I was like, I said, I feel like it's like very Jerry Springer-esque. Like it's very Jerry Springer-esque that I'm going to bring on his family on here and they're going to sit here kvetching about how he's not the same Kyle that they remember. And now he's writing a book which is revealing stuff about them that they really don't like. And it just feels like very salacious, gossipy type of thing. Now, V actually said something to me which offended me. So, because I was like, I don't know, it just feels very Jerry Springer to me. And he's like, you do that all the time. And I was saying that I was reading that text and I was like, I never ever do that. I don't know what the hell you're talking about. I never do that. The only time I've ever gotten involved in any sort of drama was when it's stuff involving people from law too. But these are people I know who are fighting with each other. So I'm like trying to resolve issues and stuff like that. This is not me inserting myself into some battle between folks who have no idea who I am. And I don't know who they are. So it's one thing me feeling like I'm trying to sort out differences between people I like versus me just all of a sudden bringing on people so they can bash, and it's basically celebrity adjacent folks bashing the celebrity to the public. That's where I felt like it is. And I'm like, so that's why I was basically like, why am I don't know why I want to do that. Like I was like, and I'm like, what is their objective? Why do they want to come on? Just so that I can give them a bigger platform and for them to yell that Kyle is ick? And do I want to be responsible for basically giving one side of the story of people who are in his life who, I'm like, if it was about remedying a situation, I would be far more inclined to do it, feeling like there's some sort of positive outcome that's an objective here. And that's why the last thing I sent him, I don't know if he responded back or not, but the last thing is I was like, what is their objective? Why do they want to come? Like, what is it? Just so I can give them, because I have, a bigger platform than other people who they know. So they like, let's use our celebrity adjacent status to bash the celebrity on the biggest platform that we can. So if they can get Tim Pool, they would take Tim Pool, clearly, obviously. I mean, I would take Tim Pool over me also. Let's face it. But it's like, so, but what's the objective? Like, if it's to like, get Kyle to like sort of dial it back. All right. I mean, then you go talk to Kyle. Like, why telling it to me in front of like thousands of people? Why would that be happening? So, yeah, this is it. Go Dr. Phil. That's what he wants. He wants me to go Dr. Phil on the Rittenhouses. Like I'm supposed to like. I wasn't. It's not like, I mean, was I a little, I was just like, should I do this? Should I not do this? And I was just like, and I was asking Lady Lawgic. I told him I was going to ask Lady Lawgic about it because apparently he talks about things about, intimate parts of their lives that they're like very bothered about that he brought up. And I was like, I don't want to talk about that stuff on my show. That's for sure. And they probably wouldn't want to talk about it. Neither of us want. I don't want to hear anything about that. That's just not what the nature of my program here. So I was just like, I don't know what I'm doing having them on. Like I can understand. It feels so gossipy to me, and I don't like gossiping. So like, I just like, I don't know. But you know what? This is what I'll do. I'm going to. I'll ask the chat. Should I host him? Start a poll. Here we go. Should I bring on Kyle Rittenhouse? How you ask the question is awesome. Vent or I'll try and be generous to them. Air their side about I'm making a yes or no. I'm not letting you guys hedge your bet. You guys have to decide. I'm probably going to go with whatever you guys decide. Not even kidding, by the way. Probably going to go with that. The movie we're thinking is Hard to Kill, starring Steven Seagal. It was Seagal's second movie. Was it? Was that it? Steven Seagal, Hard to Kill? That was Take It to the... Thank you, Joe. Was it? I think there were two movies that I was glomming together. One of them was You Could Take It to the Bank. And the other one was the guy called him Sport or Ace the entire time. Called the... Definitely Hard to Kill is around that time. It definitely is very possible because I think I saw Hard to Kill. So it's very possible. Like that's a great guess. That it's at least one of them. Death threats to an innocent kid will change you. Maybe. Sorry, I found you didn't mean to. The issue is he put personal stuff in his book about his sisters and mom, some of which is inaccurate. Yeah, okay. It's unnecessary stuff. Don't let other people's drama in your life. And I'm just sort of... I'm very torn. I mean, I think people would want to see it. I just sort of feel as if, like, I don't know if that's what I want to be doing. You know what I'm saying? That's just... If there was some sort of positive that can come out of it, that would motivate me more. But right now, unless my chat is pretty strongly in the yes, do it, I'm probably not going to. Anything perceived as and this is the other thing also. Like, do I really want to be like, oh, here's Joe leading the charge against Kyle Rittenhouse and bringing his family on here? I'm not afraid of that. I'm just like, to the extent it's successful, like, am I going to feel guilty about it? Like, there's just so many different things about this. So if I had Kyle on also, that would definitely make it much more interesting to me, where I'm actually really playing Dr. Phil. That would make it like a lot more interesting to me, like a lot more interesting like that. But I don't know, like, I have no reason to assume that Kyle's going to want to come on. I assume he probably would end up watching it, just because, like, if you know you're being talked about by your own family, you're probably going to end up watching it. But yeah, if I felt like there was some way that I could actually play a positive role in helping them, remedy the situation, I would feel a lot. I'd be genuinely interested in it. It's a bit exploitive toward your channel, but on the other hand, it's juicy content. People always have something to pay to say on those. Yeah. It's a really tough call. It's like I sort of feel as if like it's like turning my show into Vegas. It just feels sleazy. That's what it feels like. It feels sleazy. Now, if I can mask the sleaze, at least intellectually, by saying to myself, no, it's beneficial, that changes everything. Being real with y'all. All right. There's two things I want to share with you before I get to the TikTok decision. There's two things I want to share with you. One of them is the funniest thing of all time. Really like the funniest thing of all time. The other is pretty funny. Maybe I'll share the short one. I'm going to share the short one. First. Very short. Like really short. This is crazy short. And it's something I watch when I'm feeling sad and I just need to like cheer up, because sometimes I feel sad. And if I feel sad, I just watch this and it just makes me feel happy. All right. Let's refresh this. I think you need to hear from the beginning. Oh my god. The little Menchie flying out from under the seat. Flying out from from under the couch at the end there. Oh my gosh. How does this not cheer everybody up? This should make every human happy. This should make every human happy. The little man flying out from under the couch. Oh my god, that is so good. That might be the funniest thing I've ever seen in my life. That is so good. That is so good. It's not mid-humor. Come on. Come on. All right. I think it's adorable. I think it's adorable. It's also though, it's like I think it's harmless. It's not like here's the thing. I think that the people who don't laugh out loud at that basically are like too concerned about wounding people's feelings. It's like, come on. It's genuinely funny. If it's funny, it's funny. Don't let it bother you. Don't get all bugged by it. Let's get to this decision. Let's do the decision. It's a lawyer's job is to help resolve conflicts, right? Okay, yeah, but if they're just on here just killing him without him being here, that's not resolving anything. It's not resolving anything. So it'd be hilarious to bring them on and just do reaction videos that have nothing to do with anything. If I just showed one video after another, bring on the whole family, and then like never let them actually like talk about anything that's bothering them, that would be pretty funny. I would not do that. That'd be kind of a joke. Okay. So, in the United States District Court for the District of Montana, Missoula Division, State of Montana, Samantha Alario versus plaintiffs and TikTok versus Austin Knutson. When I was in 10th grade, I had a science teacher named Mr. Knutson. He spelled it the same way. It's a very memorable name because you always think you want to kick his nuts in. In this consolidated matter, just 10th graders think that's clever. In this consolidated matter, the social media company TikTok and a group of TikTok users, plaintiffs, seek a preliminary ruling enjoining the effective date of Montana's Senate Bill 419, a ban on the social media application TikTok within the territorial jurisdiction of the state of Montana. Defendant is Montana's AG, sued in his official capacity as his office is tasked with enforcing SB 419. The parties agree that SB 419 does not apply within the boundaries of the Indian reservations located in Montana. And plaintiff's motions are fully briefed. Let's go. The court heard argument on the motion's preliminary injunction on October 12th. All three parties argued. No additional evidence presented. Court granted a request to stream the oral argument at the request of the New York Times. Plaintiffs argue a preliminary injunction is necessary. Preliminary injunction, this is a restraining order. So when I have a restraining order to basically put this, they have a law that's coming that's going to like clamp them or do something to them that they don't want, mostly banning them from Montana. And they basically want to get an injunction, a stay, blocking it before it takes effect. It's supposed to take effect next month. And they want this to be blocking it and standing in its way so that they're still able to continue operating in Montana during the pendency of this litigation. So that's what they're looking for here. So they argue that it's necessary because they're likely to succeed in the merits of their First Amendment Supremacy Clause and Commerce Clause claims. The crux of each argument rests on the parties' disagreement about the constitutionality of and Montana's purpose in enacting SB 419. Despite the state's attempt to defund SB 419 as a consumer protection bill, because that's how they labeled it. They weren't stupid. They didn't say, we don't want to hear that speech. They said it's consumer protection. The current record leaves little doubt that Montana's legislature and attorney general were more interested in targeting China's ostensible role in TikTok than with protecting Montana consumers. So you're claiming that this is all about you want to protect consumers, but this definitely seems like you're targeting China and their presumed role in TikTok. This is especially apparent that the same legislature enacted an entirely separate law that purports to broadly protect consumers' digital data and privacy.
In showing its foreign affairs hand, the state has identified the Achilles heel of SB 419. For reasons stated below, plaintiffs have shown a likelihood of success as to the merits of each claim, and a preliminary injunction on the effective date of SB 419 is warranted. All right, so let's get into the background here. Let's get into it. The challenge to SB 419 comes as courts across the country grapple with the limits of government regulation. And by the way, when I was reading this, there's some things the judge wrote that I was like, I agree with, and other things I was like, I don't know. That's an interesting question. That's a really interesting philosophical question. And that's really going to be where I spend the bulk of my focus tonight. So it comes as courts across the country grapple with the limits of government regulation of large social media companies. For example, on October 20th, Supreme Court granted a shadow docket request from the United States DOJ to temporarily block a lower court's order that would limit the government's ability to communicate with social media companies about their content moderation policies. See Murthy versus Missouri. Supreme Court is also hearing oral argument in the current term on two cases involving issues like those presented here. The first case questions whether public officials' social media activity is a state action if the official posted in their official capacity. Second, and more relevant to this dispute, the Supreme Court will consider the constitutionality of Florida and Texas laws regulating how social media companies like TikTok control content posted by users on their sites. But courts and state legislatures are not alone in their concerns about digital privacy. So we're recognizing that we're having this whole big fight that's going on here about digital privacy. U.S. House of Representatives recently held hearings on TikTok operations, TikTok, how Congress can safeguard American data privacy, protect children. This fluid foundation concerning privacy, as well as the collection and use of information, informs the disputes in the matter at hand. And I'm very eager to be weighing in, says Judge Malloy, who's the name of this judge, Donna Malloy. TikTok and its users. Let's give you some background. TikTok is owned by TikTok Inc., a U.S. company, principal address in Culver City, California. Company is led by a Singapore and U.S.-based leadership team and is ultimately owned by ByteDance Limited. That's pretty funny, right? Now you just got to get some casinos on those reservations. You are good to go. TikTok is offered more than 170 countries, but is not offered in China, which is something that a lot of members in Congress keep pointing out. Why is it that they ban this stuff there? It's because they recognize how damaging it is. Based on information gathered from IP addresses, TikTok estimates that around 150 million people in the United States access the application every month. That's pretty significant. It's a third the size of Twitter, but still pretty big. Doing pretty well, including over 380,000 people in Montana. TikTok concedes that these numbers are rough estimates because it does not collect GPS information from its users. They're like, oh my God, we're just admitted when we tell you these numbers that we're actually monitoring all this stuff pretty closely, which is the whole point to why they passed this law in the first place. That's not good. Sort of tipping our hand here that, yeah, you got real reasons to be concerned. According to TikTok's president of Global Business Solutions, Blake Chandley, TikTok is an entertainment platform on which users primarily engage by creating and sharing videos or by watching and interacting with videos posted by others. People use TikTok for a variety of reasons, including for entertainment, religious, and political purposes. People, including some plaintiffs, access TikTok to generate revenue for themselves and their businesses. I don't know how anyone makes money from TikTok. I've never heard of anyone making money from TikTok, but I guess people do. I'm not sure how. Kind of curious about it. Ilario runs a local business selling sustainable made swimwear over the internet and uses TikTok to market her goods. That I can understand. Okay. Unlike other social media applications, such as Facebook, TikTok allows Ilario to market her company and gain new customers without paying for advertising. So basically, Samantha Ilario uses TikTok for marketing. She has 10 times as many followers on TikTok as on Facebook. And really, that number doesn't matter. It doesn't matter whether it's 10 times as many or 1/10 as many. The point is, if she's allowed to market there, like, do you have a right to limit her ability to market to Montana? The other users, plaintiffs, similarly use TikTok for personal and professional gains. Carly Ann Goddard uses TikTok to generate revenue by sharing her ranching lifestyle with 101,000 followers. See, I don't know how that becomes money. How does that become money? Do any of you into sponsorship deals? Is that what it is? Sponsorship deals? Okay, maybe. I guess sponsorship deals could be it. That makes sense. That would explain it. Thank you, Dr. D's Nuts. Her YouTube following is a minuscule 157 individual accounts. Similarly, Heather DeRocco. I see that doesn't matter because whether they have other success on social media or not should not be relevant. I see this is where the judge starts losing me. Like, why are you even bringing this up? Because that's not relevant. I don't care if it should not matter from a philosophical or legal perspective whether the plaintiff is someone who is making $1 million on YouTube and $20 on TikTok, or 20 million on TikTok and $10 on YouTube. That's not relevant to this. So that's why I don't understand. Why would that be relevant? Because I can't figure that out. Heather DeRocco used TikTok to discuss issues like mental health and suicide prevention with fellow veterans around the country. She has over 200,000 followers on TikTok, but only 23,500 on Instagram, and earns approximately 10 to 30% of her annual income through the TikTok application. Okay. Again, I don't know why that's relevant. And when I see stuff that's irrelevant, that's thrown in as if like, oh, yeah, that just makes me question the philosophical underpinning of the person who's issuing the decision. TikTok data security and age restrictions. TikTok collects usernames, dates of birth, phone numbers, email addresses from its users. Information users voluntarily report before use. Users agree to TikTok's data collection policy when they sign up for the application. TikTok affirms it has not received any request for U.S. user data from the Chinese government. So, like, we don't know why you think the Chinese are here. It doesn't. There's no Chinese people here. We never got a single request from the government. Okay. And that it has not shared any U.S. user data with the Chinese government in response to such requests, and would not do so if it were to receive a request. Okay. That's what they claim. TikTok's privacy policy regarding data security and retention states: we retain information for as long as necessary to provide the platform and for the purposes set out in the privacy policy. We also retain information when necessary to comply with contractual and legal obligations when we have a legitimate business interest to do so, such as improving and developing the platform and enhancing its safety, security, and security, and for the exercise of defense of legal claims, retention periods, and depending on different criteria, such as type of information and purposes for which we use the information. For example, when we process your information, such as your profile information, to provide you with your platform, we keep this information for as long as you count. If you violate our terms of service, community guidelines, or other conditions, policies, we may remove your profile immediately, but you may keep other information about you to process the violation. TikTok may transmit your data to servers, data centers outside the United States for storage and processing. Other entities with whom TikTok may share your data, as described here, may be located outside the United States. The extent to which China controls TikTok and has access to its user data forms is the heart of this controversy. Okay. The state's factual position presented mainly in the form of citations to news coverage is that the Chinese government has a super user credential that allows it to access the personal information of any TikTok user data it can access without asking either ByteDance or TikTok. So what they're basically saying is, you're coming along and saying they've never asked us for information. We would never, ever, ever, ever give them any information if they asked for it. But instead, they built into the system where President Xi can like log in and see whatever he wants without having to make a request. Obviously you do. Everyone does. Prospering says TikTok is the number one advertising platform for consumers aged 13 or 30, and TikTok pays for views of videos just like YouTube. Do they really? Do they? I don't think that they do. It could be. You would think that they would. I don't think that they do, though. Maybe. Okay. Maybe they do. I remember mocking Legal Mindset about his 200,000 followers on TikTok. And he's like, yeah, I never made it down from that. So, I don't know. I have all like 50 followers on TikTok. I've made like 3 stupid clips there on TikTok. The last one was like a year and a half ago where I said, okay, fine, I'll make a lot more TikTok videos. That's my use of TikTok. The state's factual position, presented mainly in the form of citations to news coverage, is that Chinese government has a super user credential. And this great general concern over TikTok's data practices is shared by other United States jurisdictions. TikTok's own data security expert testified by affidavit that China reportedly hacked into United States government data through the Office of Personnel Management. In response to federal concerns over TikTok data practices, TikTok created internal systems to safeguard U.S. user data and prevent foreign access to TikTok data systems. TikTok also contracted U.S.-based Oracle Corporation to serve as a cloud storage facility for all the U.S. user data. TikTok has features, policies, and procedures aimed at limiting the content minors can access in the application. This guy sounds like he loves TikTok. No? He sounds like he really I really, really like me some TikTok vids. For example, TikTok has community guidelines that prohibit users from posting certain categories of videos to the app, including videos that feature nudity, sexual activity, sexually explicit or exploitative content, as well as videos that appear dangerous or otherwise harmful. To enforce the community guidelines, every TikTok video must pass through automated moderation. So the content is flagged as potentially violative and can be automatically removed. They got also age-based settings. They're taking steps. They're doing what they can, according to TikTok. That's what TikTok is saying. FYI, Chris Cuomo was on PBD podcast yesterday, and believe it or not, was very good. Fredo has made a mea culpa and made some good points on politics, Trump, Biden, etc. I've watched these guys before; they're pretty fair. I do like the PBD podcast. I like him. I think he's entertaining. Here it is for you. Here for you if you start learning some dances. Oh, is that what you want to see me like doing my thing? I'm not doing any TikTok challenges. That's not happening. I'd rather interview the Rittenhouse family. Speaking of which, how is that poll coming along? 56% saying no. That's where we're at. That's where we're at. See, my viewers, they want to keep me pure and clean, untainted, unsullied. They're trying to keep me unsullied. Thank you. They're trying to keep me unsullied. So here we go. Let's get into the act. This is the act that they're trying to stay on. Let's break down the act, what it's about, how it works, or why it shouldn't work according to this court. On May 4, 2023, Montana legislature passed Bill SB 419. Governor Greg Gianforte signed the bill into law with the following month. Montana legislature, blah, blah, blah. SB 419 bans TikTok from operating within the territorial jurisdiction of Montana. It imposes a $10,000 penalty on either TikTok or a mobile application store for each time a user accesses TikTok. That's a pretty steep price to watch a 30-second video. Or is offered the ability to access TikTok, or is offered the ability to download TikTok, and an additional $10,000 assessment for each day the violation continues. It's purposefully designed to be very costly, so no one tries to circumvent this. SB 419 is scheduled to take effect January 1, intended to be codified as an integral part of the Unfair Trade Practices Act. The preamble states 2 reasons for the ban. First, because TikTok is wholly owned subsidiary of ByteDance, a Chinese corporation. And because TikTok gathers significant information from its users accessing data against their will to share with People's Republic of China. So these 2 reasons, are they supposed to be working together? It's because it's a wholly owned subsidiary. Does that mean that any other wholly owned subsidiary of China we would not ban? Is that what it's saying? Or any one of these standing alone? The fact that it's gathering information to share with the People's Republic of China, that you would think standing alone would be enough, right? Well, anyway, SB 419 is necessary to prevent both the Chinese Communist Party and People's Republic of China from conducting corporate and international espionage in Montana. Prevent the Chinese Communist Party, CCP, from engaging in international espionage in Montana. So you got to basically establish that that's really okay. Okay. Ostensibly for this reason, SB 419 is void. TikTok is acquired or sold to a company that's not incorporated in any other country designated as a foreign adversary at the time TikTok is sold or acquired. Meaning, sell it now. Sell it now. Go ahead and sell it. We don't like it being part of China. Second, the preamble asserts that TikTok fails to remove and may even promote dangerous content that directs minors to engage in dangerous activities. Under dangerous content, it says this list includes People's Republic of China, including the Hong Kong Special Administrative Region, Republic of Cuba, Islamic. Oh, these are the bad. These are the people we don't like. The Islamic Republic of Iran, Democratic People's Republic of North Korea, the RF, and Venezuelan politician Nicolas Maduro. Okay. Okay. All right. And the bad practices that they got kids to do includes but not limited to throwing objects at moving automobiles, taking excessive amounts of medication, lighting a mirror on fire. How do you do that? And then attempting to extinguish it using only one's body parts. Inducing unconsciousness through oxygen deprivation. This is how you know it's only Gen Z on there. Cooking chicken in NyQuil, pouring hot wax on a user's face, attempting to break an unsuspecting passerby's skull by tripping him or her into landing face first into a hard surface. And I'm sitting here having second thoughts about bringing Kyle's family on here because I'm like, no, that's too low. Placing metal objects in electrical outlets, swerving cars at high rates of speed, smearing human feces on toddlers. Why? Why? Why are there people like this? Why? I don't. Why? Just why? Why? Licking doorknobs and toilet seats to place oneself at risk of contracting coronavirus, attempting to climb stacks of milk crates. See, I don't think there's anything wrong with that. Shooting passerbys with air rifles, loosening lug nuts on vehicles, and stealing utilities from public places. Okay. Small minds discuss ideas. Who cares about the book? Okay. So that's the reason why they say they want out of here. Now we're gonna have Judge Malloy break this down. Let's see how well he does this. But I will tell you this: you asked me to have a poll. So I put a poll. 57% say no. So there you go. That's the end of it. 57 say nope, don't have the family on. So we're going to pass. New poll here. This is a harder one, I think. Should states be allowed to ban TikTok? This is a really interesting poll, which I think we're going to have this just be yes or no. I want to look over here. In Rumble, I'm looking at you, ghetto folk. I'm looking at you, ghetto folk. Put 1 if you think yes, they should be allowed to ban. 2 if you think no, they should not be allowed to be banned. Given what we have so far. Yes or no. Because the bad ideas that they're supporting, they're throwing out there, is that relevant to China? What if they were American? It seems like they'd be okay with that. If you sell it in America, then that's okay. So we'll let you put this stupidity out there and put people at risk, as long as it's not owned by China. Why? In that case, is it relevant? Or is it just that this is a reflection of how China is trying to basically mess up Gen Z for us? There's 200 of you there, and I can't get anyone. It's weird stuff. For national security reasons, yes. However, probably not possible. Internet routes, damages, and all. I want to check over on my locals folk. Give me diggers. 1 for yes, they should be allowed to be banned. States should have the power to ban them. 2 for no. Joe Sound Guy says no. Boo. Stop it, Viola. Divine spirits were that it's going to spread like toxin, like ricin. Derna says states can require 2-party consent for audio recording. They should be able to ban data collection practices. Should have gone that route. The problem then is that they would have to ban Facebook and Twitter and all these other folk that they don't want to ban. That's really the problem. That's the problem they're having. So Viola's saying yes, they should be allowed to ban. This is a tough one. Enjoy your shower. This is a tough call. This is not an easy one for any of us to figure out. So let's see how this judge did it. Preliminary injunction is an extraordinary remedy never awarded as a right. Okay. To analyze a request for preliminary injunctive relief, you have to get 4 things in the federal court. 1, likelihood of success in the merits. 2, likely to suffer irreparable harm absent preliminary injunction. 3, balance of equities. And 4, preliminary injunction is in the public interest. That's something that they have in federal court that does not exist in New York. This whole concept that it's got to be in the public interest. Okay. However, when plaintiffs establish that the balance of hardships tips sharply in their favor is the likelihood of irreparable injury and the injunction is in the public interest, then he only shows serious questions on the merits. Ooh, you don't show likelihood of success, just serious questions. Interesting. That's another little wrinkle in federal court, at least in the Ninth Circuit. In this case, plaintiffs have demonstrated each element. Consequently, preliminary injunction is warranted to enjoin the effective date of SB 419 pending a final determination on the merits. So this law is not going into effect until we finish it up with it here. We're going to get to the bottom of this before I'm not letting this. The judge says I'm not letting this go into effect. All right. So, likelihood of success in the merits means I think they're going to win. They displayed a good chance of winning this case. Plaintiffs argue they're likely to see the merits in 3 ways. 1, SB 419 does not comport with the First Amendment. 2, 419 is preempted by federal national security law. And 3, there's Swalwell. 419 violates the Commerce Clause. I guess international commerce being a federal issue, not a state issue. In response, state argues, 1, 419 is a valid exercise of Montana's police power, so therefore the First Amendment is not implicated. Which basically is we put this as consumer protection, which is police power. We're keeping our citizens safe. So we're allowed to do what we need to keep them safe. 2, preemption does not prevent Montana from legislating to ban TikTok. So we're going to have to look at what this is preemption by federal national security law. And 3, 419 has only an indirect effect on interstate commerce. It's not really about interstate commerce. Very limited effect on interstate commerce, which is permissible under the Commerce Clause. Because plaintiffs have the better arguments, they have demonstrated likelihood of success in the merits. So let's talk about these 3 arguments. First Amendment. This is the big one. Plaintiffs argue that 419's total ban on TikTok unconstitutionally targets speech and that the law is subject to the highest level of constitutional scrutiny. It would get that. Okay, so the state disagrees, arguing that the extent 419 implicates the First Amendment at all, it merely regulates expressive non-speech conduct. Thus, it need only pass intermediate scrutiny. Like the curate's egg, neither argument is entirely persuasive. So I'm torn. He's like, I'm torn. I'm not sure if this is free speech or this is intermediate scrutiny. However, because plaintiffs have shown that 419 is unlikely to pass even intermediate scrutiny, it likely violates the First Amendment, protected expression versus non-expressive conduct. Because plaintiffs argue 419 implicates the First Amendment, the threshold question is whether the First Amendment applies to conduct and speech that the bill prohibits. TikTok argues that 419 infringes on its First Amendment right to make editorial choices over content curation. Now, this is a very strange thing to me. So let's think about the different people who are involved here and who's engaging in free speech. Is TikTok itself engaging in free speech? I can understand that every content creator on there is engaging in free speech. Whatever stupidity they're doing, whether telling a joke or doing a dance or trying to do something funny, and they make the edit and they make the video and they make edits in the video and changes and music and lighting and all this other stuff. That's all art. And sharing their art seems like free speech. Is it the ability to speak in this venue is the real question I have. But let's put them aside for a second. Just look at what TikTok itself is. TikTok is a platform, right? They're not the ones creating the content. They're just a place for the content to appear. So they themselves, I would think, are not engaging in free speech. And even if they're promoting this speech versus that speech, to the extent they are doing that, if anything, that tells me that they should not be getting Section 230 protection because they're acting as an editor, not as a distributor. And why the hell are they getting this Section 230 protections? It's a fascinating question. I mean, the whole point of Section 230 is, since all these platforms, they're not really monitoring, they're not really editorializing anything. So that's why we're not going to hold them liable if someone commits defamation on a platform because it's not under their editorial control. Well, what's TikTok saying over here? They're like, well, it's under our editorial control. So since we have editorial control, it's our speech, and our speech is being limited. So we have a right to come in here and try and stop this because it's a violation of our freedom of speech. It's like, how is this? The whole point as to why we have Section 230 is because supposedly there's no speech by the platforms. And they're not doing anything to affect speech. And this to me is something where I'm just philosophically, I'm very bothered by this. I plan on talking about this with my peers tomorrow on Laid Back News. And talking about this concept with them as far as whether or not it's TikTok speech, free speech issues. Now we'll get to the content creators themselves. It's going to come up, and we'll talk about that, and whether it's infringing on their free speech rights if you don't enable them to go on every platform that they want, or go on that platform but to be aired in every state that they want. You know, on the platform, we're just not allowing it to be viewed here. So who's the speech? It's the viewers who are unable to watch it. Freedom of speech, usually we would think of as being a protection for the speaker. Well, they can go up there and speak. It just can't be viewed in Montana. So go ahead and speak away. But it's like, even if you're a content creator, if you can't get, I can't push this that I'm doing right this second. I cannot push this in a place that does not have internet capacity. Is that inhibiting my speech? No, it's intended for places which are able to get YouTube and upload it. And if they don't allow it in China, no one in China is going to see me, unless they're on Rumble, because Chinese people are based. I'm just kidding. But my point is that any places that have a ban on YouTube, so is that limiting my speech? I can speak. It's just that the people out there who want to hear or may want to hear are unable to hear because of laws that are stopping them to be heard. They're not stopping. So Montana here would not be stopping the creator from speaking. They're really stopping the listeners from hearing. Now, that might sound like a distinction without a difference. But and maybe it is, but at least we should recognize it's not exactly the same thing as saying you can't speak, saying that, no, our residents cannot listen. That's not exactly the same thing. And I wonder whether freedom of speech protections, I would think, probably we wouldn't want the government infringing on our ability to listen. But I don't know if that protection is as strong as limiting our ability to speak. Because as we know, most humans are inclined to speak a lot more than they are to listen. That applies to every one of us. So that being the case, perhaps freedom of speech protections are broader than freedom of listening protections. And I guess perhaps any Montanans who might want to speak on the platform will be unable to use the platform. So those potential Montanan platform content creators, TikTok content creators, they would be having their speech limited. I'm just trying to dissect this and wrap my brain around what's actually happening here. It's a really interesting conversation. And so, like, sometimes, like, a conversation like this, I think I would really like to have another attorney who's like a free speech, who understands constitutional law, just to sort of bounce ideas and thoughts off with them as to, like, what the purpose of why the First Amendment is so sacrosanct, and what is making for a violation of that First Amendment right. And is it on the speaker or for the listener? But I would actually understand an argument to say that freedom of speech is much more protective of your right to speak than it is of your right to listen. So to the extent that anyone is in Montana and wants to watch a TikTok video and they want to be able to watch it, now you're stopping them from watching it, I don't think that they have much of a claim. To the extent that someone outside Montana wants to have Montanans hear them on TikTok, I don't know that that's much of a claim. Not as much as freedom of speech. It's not as strong a claim as a Montanan who says, I want to be able to speak on this platform. My government is stopping me from doing that. To me, that's a more egregious violation of the First Amendment. The former step may be a violation as well. I just don't think it's as clear cut. That's my point. So TikTok argues that it infringes on First Amendment rights to make editorial choices. And when we're coming back to looking at TikTok itself as a platform, it's very difficult to understand why TikTok itself we should be concerned about their speech when the whole point of Section 230 is a recognition by Congress that they're not speaking. They're not editorializing. It really flies in the face, and that reminds us that we really need to revise Section 230. And user plaintiffs argue the right to speak on the platform is limited by SB 419. So this I would agree with. If you're a content creator and you live in Montana and you're like, I want to be able to speak on this platform, and this new law makes it a crime for me to do that with stiff penalties, that seems to be infringing on the right to speak. I can understand that. The state counters the bill is merely a generally applicable consumer protection law that does not implicate speech. But if the bill implicates speech at all, it merely bans non-expressive conduct, meaning they say it's not really about speech. And if it does, it's just non-expressive conduct that contains a speech element. What the hell does that mean? Non-expressive conduct that contains a speech element. It's conduct actions that's not expressive of people speaking. How do you come up with that? What's the logic to say that it's non-expressive conduct? How's it non-expressive? What are you saying? All TikTok videos are crap? So it's not really expressing? It can't be that. I mean, even if it's true, they have to recognize that's not going to fly. All right. The state's defense of 419 rests on the proposition that the First Amendment is not implicated at all because the bill does not regulate speech. It argues instead that because the legislature may make its own reasoned judgment about what conduct is permitted or prescribed within its borders, its TikTok ban can sit comfortably alongside many other generally applicable consumer protection laws. So we're not going to allow you to saw your own hand off. We're not going to allow you to take a drill and drill it into your skull. And we're not going to allow you to listen to TikTok. While there's speech happening on TikTok, it's still something that's potentially dangerous for you. So we're just protecting you from you harming yourself by participating here on the platform, if that makes sense to you, which it does. And I mean, there's logic behind the claim that it's a consumer protection issue, meaning and then I guess that's what they mean by non-expressive conduct. That the same way that they have a right to protect you from has a right to protect you from Ebola, due to protect you from Ebola. They have a right to protect the public from someone who's dropping dumbbells from the top of a skyscraper. They have a right to protect you from self-harm. So they have a right to protect you from self-harm in the form of listening to really crappy videos. There's logic there. This is why the judge is torn. He's like, it is sort of between free speech and consumer protection conduct. The state and Amicus Virginia are correct that consumer protection laws fall in an area that is traditionally within the state's police powers to protect its own citizens. However, 419 is not merely a generally applicable consumer protection statute without any First Amendment implications. In Akara versus Cloudbooks, a case in which the state heavily relies, Supreme Court considered whether a state statute authorizing the closure of premises designated public health nuisances could be applied to shut down a bookstore because the store was being used for soliciting prostitution. In that case, New York initiated an enforcement action against a bookstore specializing in selling sexually explicit books and magazines with booths available for the viewing of sexually explicit movies. So they want to show these things and basically have booths where there's a lot of fluids going around, which might lead to people contracting diseases. And they're like, well, we want to be, it's freedom of speech, so we can show this. And New York's like, dude, you're like going to cause people like get like grossly sick. Like, we have freedom of speech. We can show what we want here. So when prostitution allegedly also occurred there, the store argued that shutting down the business because of the prostitution activity interfered with its First Amendment right to sell books. The Supreme Court held that the store's activity manifested absolutely no element of protected expression. Rather, the story sought to use the First Amendment to cloak obviously unlawful conduct by attributing protected expressive attributes to the conduct. Basically, like claiming that performance art is art. The court further explained that First Amendment scrutiny need not be applied to conduct unless the conduct has a significant expressive element that drew the legal remedy in the first place. So you don't just because you're engaging in speech doesn't mean all of a sudden like, oh no, First Amendment just kicks in here right away. That's not what happens. Or where a statute based on non-expressive activity has the inevitable effect of singling out those people engaged in expressive activity. The state argues that 419 bans TikTok because of its allegedly harmful data harvesting practices, and that TikTok's conduct has no protected First Amendment expressive attributes. If it were not allowed to regulate TikTok in this way, the state argues it would be akin to prohibiting Montana from banning a cancer-causing radio merely because the radio also transmitted protected speech. It's a good analogy. That's a good analogy. I like that analogy. It's a smart analogy. Let's imagine that a radio is giving off, like, cancer with the waves or whatever that are coming out of it, and there's also you hear someone speaking like, "Well, you can't touch that. It's a free speech." It's a very good analogy, but the court disagrees with me. The state analogy is not persuasive and is seemingly undermined by the separate passage of SB 384, which, as discussed below, broadly protects consumers' digital data and privacy. So it's like the court is saying, even if that argument, even if I found that argument to have meaning, they're already protected from this because of this other law you passed. So you're not really protecting their privacy. Basically, what the court is saying here is there is no cancer. That's basically what the court seems to be finding. You're claiming you're trying to keep your citizens from getting cancer, but there is no cancer here because the data privacy, you're trying to protect their data privacy. Well, you already just passed a different law, which is data privacy. So why are you passing that law? Obviously, you think it's going to protect their privacy. I don't know if that makes really sense, though. Just because they take one step to protect data privacy doesn't mean that that's going to remedy the entire situation. I'm not really agreeing with the judge and his logic here. I appreciate his efforts to wrap his head around it, and I don't think he's being stupid. I just disagree with his conclusion. Because I think he's sort of pretending that, well, once you have one remedy, clearly that's enough, which doesn't make any sense. By that logic, well, if I have brakes in my car, I don't need a seatbelt because I already have a remedy to keep me from getting hurt inside my vehicle by having brakes. So, you have a seatbelt also. So I don't really agree with it. I don't agree with his conclusion here. Let me catch up on some of these chats. Actually, let me see. You can see why I'm enjoying it because it's like this is really like a very rich type of logic as far as understanding our constitutional perspectives and laws. Okay, so I'll get when I get there. On page 14. First, SB 419 is not generally applicable law, like those in our CARA, which authorize the closure of any building found to be a public health nuisance. Unlike that law, 419 targets one entity, specifically going after to TikTok, which already makes it not generally applicable. Second, court in our CARA determined the conduct there was non-speech, subject to New York's general regulation that had absolutely no connection to any expressive activity. There's really no expression going on here, and that's not a claim that Montana can make here. For both groups of plaintiffs, 419 implicates traditional First Amendment speech. It does so for plaintiffs by banning a means of expression, user plaintiffs by banning means of expression used by over 300,000 Montanans. And without TikTok, user plaintiffs are deprived of communicating by their preferred means of speech, and thus First Amendment scrutiny is appropriate. See, for them, I can get that. Like I said, it's really for Montanans, not the 300,000 people listening. Because it's not expression to hear something. It's expression for the speaker. So this is the judge getting close to the mark as far as being intelligent about this. But I think respectfully missing it just slightly. It's because remember when I said earlier, I said, why you care about how many users he has on this platform versus that platform? It's either okay or it's not okay. And how many users you have, whether it's 3, how many followers you have, whether you have 3 followers or 3 million followers, doesn't matter. It's really not relevant to the principle of the matter. And over here, he gets into a whole thing of a means of expression used by over 300,000 people. Who cares if it's used by 300,000 or by 3 people? That's not the point. And this is where he's missing the point in a way that's frustrating to me. I think he's being he's being a little bit dense about this. Where he's making a big deal about the 300,000. It's not about the 300,000 users who are listening. That's not the persons whose rights are being affected. It's the 25 Montanans who are creating content, or I don't know, 2,500 or 25,000 Montanans who are creating content and not able to share that content on this platform. And whether they're sharing it with 3 people or 3 million people, that's the point. Is their free speech is the one that's really being restricted here. I don't care how many people are able to listen, because that's less a matter of free speech, the right to listen. Without TikTok, which I guess I'm proving the point that if a tree falls in a forest and there's no one around to hear it, well, at least it had the opportunity to make that noise. Without TikTok, user plaintiffs are deprived of communicating by the preferred means of speech. And it doesn't matter if this is their preferred means of speech or it's their 57th most favorite means of speech. It's still First Amendment. That's my point. This is where I'm saying this sentence is what ticked me off, because saying it's their preferred means of speech. It doesn't have to be their preferred means of speech. Even if it's their 137th most favorite form of speech, doesn't matter. But that's why he seems to make a big fixation as to like how significant the harm is to these folks. Likewise, SB 419 implicates TikTok speech because the application's decisions related to how it selects, curates, and arranges content are also protected by First Amendment. 419 prevents the company from the presentation of an edited compilation of speech generated by other persons, which of course falls squarely within the core of the First Amendment security. So this is where I'm really going to have a problem with what he's saying here. So TikTok speech, because the application's decisions relate to how it selects, curates, and arranges content, are also protected by the First Amendment. Really? Really? These speech concerns place 419 and the activity banned square within First Amendment protection. See, I don't think you need to get onto TikTok's deprivation of its First Amendment. I don't see this as being a First Amendment thing for TikTok at all. How they select, curate, and arrange. I understand that can be expressive. I'm not disputing that. I'm simply saying they're supposed to be not doing that. That's the whole point. That's why I have a problem with it. I knew what you meant, Ryan. So the phrase I think you were looking for is small minds discuss people, mid-level minds discuss things, and great minds discuss ideas, or something to that effect. Derna says states can require two-party consent for audio recording. They should be able to ban data collection practices. Should have gone that route. I agree with you. V, I initially wanted to ban it, but Glenn Greenwald's points about it are valid. The government should not be able to ban platforms. Remember Parler? Yep. Yeah. Cult follower number 6, Joseph. Obviously, we don't have the freedom to choose wrong things anymore. So please, government, be our content filter cutters. Jenny. See the people walking down the street, fall in line, just watching all their feet. They don't know where they want to go, but they're walking in time. They got the beat. See the people walking down the street, fall in line, just watching all their feet. They don't know where they want to go, but they're walking in time. They got the beat. They got the beat. They got the beat. Yeah! They got the beat. You got your $20 worth. It's considered art because it's not the baby's poop. Yeah, I guess so. And sometimes it is. Oh, they know it's when they're smearing the feces? Yeah. TikTok, big duty. However, could just be a slippery slope. Yeah. See, Lily, that's what we're all grappling with. We're all like, really don't like TikTok so much. I really kind of want them banned. Really don't like the idea of the government doing it. I just wish that like Gen Z didn't suck. That's basically what we're all thinking. Why does Gen Z suck so much? Outlawing lead and paint would be similar. Fair enough. Fair enough. Was that? I think I really gave Jenny her money's worth there. We got the beat. We got the beat. They want Rumble taken down for not censoring. Yeah. Yep. Yep. That's what the world's coming to. All right. So the First Amendment analysis. Although the First Amendment protects these activities, legislature may still regulate them. So it's protected, it can still be regulated. It has to do something with constitutional scalpel, fine knife, to meet the confines of the Constitution. Accordingly, it's necessary to determine what level of constitutional scrutiny to apply. Plaintiffs argue that 419 has to pass strict constitutional scrutiny because it's a prior restraint, a content-based restriction, and a viewpoint-based restriction. Is it viewpoint-based? State does not concede that any First Amendment analysis applies, but argues that if it does, it regulates non-expressive conduct, and thus a lower level of scrutiny is required. Although neither side is completely correct, the state has the better argument as to the level of scrutiny should be applied. However, even applying the intermediate scrutiny, state fails to show how 419 is constitutionally permissible. Content and viewpoint based versus content neutral. Okay, so he's going to explain why it is. He wants this to be read. This was a decision that was written to be read. He's like, I'm going to break down every freaking argument here. I just explained to you how I'm rejecting this standard. And even though I'm going to give you the win, I'm explaining to you why, overall, I'm explaining to you why you're getting the loss on this standard. So this way, when this is ultimately reviewed by the Supreme Court, they can hopefully applaud my thinking. That's what this judge is thinking when he writes this thing. So plaintiffs argue that SB 409 is a content viewpoint restriction on speech for which strict scrutiny analysis applies. On the other hand, state says intermediate. And because it only regulates content neutral expressive conduct. So content neutral is, I'm not trying to come down on the right. I'm not trying to come down on the left. I'm not trying to come down in favor of abortion or against abortion or anything of that nature. I'm simply stopping people from being able to use megaphones. That's affecting people equally, no matter what their viewpoint is. Since it's content neutral, so we would apply a lower standard rather than if it's punishing one side of the aisle where we would have a stricter standard. We would have that much more, we want to be that much more careful about allowing the government to do such a thing. Neither argument is completely accurate, but the state's closer to the legal mark. The principal inquiry in determining content neutrality in speech cases generally and in time, place, or manner cases in particular is whether the government has adopted regulation of speech because of disagreement with the message it conveys. As a general rule, laws that by their terms distinguish favored speech from disfavored speech on the basis of ideas or views expressed are content-based. By contrast, laws that confer benefits or impose burdens on speech without reference to the ideas or views expressed are in most instances content neutral. Montana, 419 bans TikTok from operating in Montana. Parties disagree as to whether this ban is with or without reference to the speaker's ideas. In IMDb.com versus Becerra, Ninth Circuit held that a state statute prohibiting dissemination of personal information of celebrities on the internet was content-based because it prohibited one type of speech and a single category of speakers. It's a pretty stupid finding. Sorry. In another First Amendment case, Ninth Circuit held that local ordinance prohibiting the parking of mobile advertising billboards on public streets was content neutral. That I can agree with. because it doesn't matter what the message is. They'd be like, we don't want any billboards here. We don't care what the message on the billboard is. Like in IMDb, 419 restricts TikTok videos and TikTok users from speaking, does not consider the message of the speaker, merely the act of speaking itself. Doesn't matter whether they're MAGA or some crazy blue-haired kid. So that makes it more content neutral. 419 restricts the manner of the speech, but it does so by banning the platform completely, not just where the platform can be used. Thus, neither IMDb nor Lone Star is exactly on point. Neither is the state's preferred case study of U.S. versus O'Brien. In O'Brien, individuals protesting the Vietnam War burned their draft cards in violation of federal law, subjecting anyone who knowingly destroys or mutilates a draft certificate to be criminal liability. So they say, hey, we want to show you that we're not going to show up for your crummy war. And they probably didn't say crummy. And they set their draft cards on fire. Well, so then the government's like, oh, you're breaking the law. Like, no, we're making a speech. We're making it's free speech about our position on the war. So the Supreme Court held that because the law did not directly implicate speech and created multiple other justifications unrelated to the suppression of speech, the statute was constitutional, which to me, that's a terrible finding because that's clearly free speech. That's clearly engaging in a point about how they feel about the war. But here, where the law directly and immediately affects First Amendment rights, I guess they're saying someone who's destroying the car, someone doesn't have to be speech. That about it could just be that it could be getting rid of evidence. So anyone who mutilates it, it might not be a public statement, and the law is against mutilation of the draft card. This is so complicated, but it's fun. Here, the law directly and immediately affects First Amendment rights. O'Brien is applicable. In this case, 419 completely bans a platform where people speak, so it directly implicates speech. Thus, O'Brien is not directly applicable for the reasons the state claims. As an alternative analysis, TikTok argues that 419's content-neutral regulation on speech that merely restricts the time, place, or manner of protected speech and is therefore subject to intermediate scrutiny. 419 bans a single social media application has over 300,000 monthly users in Montana. He loves saying that. Today's social user websites like TikTok are for many principal sources of knowing current events, checking ads, and basically how people connect with the world. Attorney General Knudsen, who wrote the bill, went on national public speaking tour touting its merits, agrees. In his remarks in the House Judiciary Committee when the bill was introduced, Knudsen said, when we're talking about the First Amendment, what's the best way to get your message, to get your free speech out there? It's no longer to stand on your apple cart in the public square, give a speech. It's get on social media. We know that. Best way to spread your message is via social media. This sentiment is almost verbatim to the Supreme Court's position on the subject, that social media allows a person with an internet connection to become a town crier with a voice that resonates far further than it could from any soapbox. Following this line of reasoning, 419 could be seen as a restriction on the time, place, or manner that a person could speak in the public forum, that is, the internet. Given such a prescription, intermediate scrutiny should be applied here. Meaning, yeah, you can speak, but in the time, place, and manner that we allow you to speak. Time, place, and manner is basically a loophole that the government can get around and say, we're not stopping you from speaking. We're just restricting the time, place, and manner where you can speak, which that governments have been held that they have a right to do that. So we're restricting your time, place, and manner, that the place is not TikTok. For a preliminary injunction to issue, it only requires determination of a likelihood of success in the merits. It's unnecessary to precisely categorize 419's content-based and content-neutral time, place, manner restriction because it is likely the bill is, at the very least, a regulation of expressive conduct that triggers intermediate scrutiny. Additionally, at the October 12th hearing, parties acknowledged that at least intermediate scrutiny should be applied. So I got basically the government to admit that there should be intermediate scrutiny. So even if 419 is only regulation of conduct that puts an incidental burden on speech, it must at least pass intermediate scrutiny. All right. Prior restraint. Plaintiffs layer their argument for a higher level of scrutiny by asserting that SB 419 is a prior restraint that completely limits one form of speech. The state disagrees. Instead, the state argues that plaintiffs can use any other online video platforms and reach their intended audience using these other platforms. Not really true, because some users only use TikTok. That's a pretty weak argument. In this limited circumstance, the state has the better argument. What? No. That's like saying build your own website. That's ridiculous. The state's argument is, well, we're not saying you can't use the internet. We're just saying you can't use this platform. What? But what if the people I want to reach are only on that platform? That's ridiculous. That's ridiculous. Go build your own platform. What a stupid... And the judge is buying this? Ugh. Ugh. No. I just lost all respect. I just lost it. Respect gone. Out the window. Gone. You're saying that this platform is the same as that platform? It's like the Rumble folk who are telling me that Rumble's just the same as YouTube. Yeah, well, that's the people trying to survive off the income. A prior restraint is an administrative and judicial order forbidding certain communications when issued in advance of time that such communications are to occur. I can clearly not trust the wine in front of me. Inconceivable. A prior restraint is the administrative and judicial order communications issued in advance of time that such communications are to occur. In U.S. WeChat Users Alliance versus Trump, District Court recently considered challenging an executive order prohibiting people in the United States from using WeChat, a messaging social media mobile payment application. The case provides some guidance here. Okay. Another place that's banned, that would seem to provide guidance. WeChat users sued, argued, like here, that the executive order was prior restraint on First Amendment speech. District Court agreed. It found that because WeChat was the only platform available to Chinese speakers with limited English proficiency to communicate in the way they wanted, no viable substitute platforms or applications existed for the Chinese-speaking and Chinese-American community. I don't understand any of these judges who are no, what about the fact that you want to talk to these people and you can only do it on that platform? Here, like the ban on WeChat, 419 completely shuts off TikTok to Montana users. But unlike WeChat, TikTok users may be able to use other platforms on the internet, assuming they're willing to forego its benefits. There is evidence to support plaintiff's position that TikTok is not interchangeable with other social media applications. Yeah, there's a lot of evidence that no two platforms are the same because they all have different users. The state provides no support for the conclusion that user plaintiffs may simply substitute another social media site in place of TikTok to achieve the same effect. Yeah, because there is no explanation for that. Government's wrong on that. It is a no harm, no foul argument. That's crap. That's not true. That said, the state persuasively counters that unlike WeChat, there's no language barrier preventing user plaintiffs from accessing other social media applications. So what? There's perhaps an economic consequence, but not a ban on the user's sole means of communicating. So that does not mean that those other channels are sufficient to satisfy the intermediate scrutiny analysis, but they may be sufficient to satisfy the prior restraint analysis. On the record, at this preliminary stage, plaintiffs have not shown it is likely that 419 is a prior restraint on protected speech. Let's talk about intermediate scrutiny. So now that we came to this intermediate scrutiny standard, let's start analyzing exactly how that works. Because not a lot of things have intermediate scrutiny. Not a lot of things. You want to know what has intermediate scrutiny? Gender discrimination. Unlike racial discrimination, which has strict scrutiny, the sterner scrutiny, where we stop the government a lot more often, gender discrimination as intermediate scrutiny. To pass intermediate scrutiny, a law must both advance important government interests unrelated to suppression of free speech, not burden substantially more speech than necessary. Substantially more. Okay. So it has to have an important government interest and not burden substantially more speech than necessary. At least, because you have strict scrutiny, you have intermediate scrutiny, and then you have rational relation tests. Strict scrutiny is it has to be narrowly tailored for a purpose that is not just important, but it's got to be for a essential purpose, I think, as opposed to rational relation test, which is the exact opposite, which is that if there's any sort of legitimate basis at all, and this will get the job done. Okay. And it's got to leave open alternative channels for communication of the information. Conceding for the sake of argument, the state may have at least an important state interest. So we think that they may. It's possible that China's a threat, or that these people are going to hurt themselves if they start climbing up milk cartons or trying to like lick doorknobs and toilet seats. So if we accept that, the law is not narrowly tailored, nor does it leave open alternative channels for targeted communication of information. So therefore, that's why 419 doesn't pass immediate scrutiny. So what is the legitimate state interest that they say? 419 states that the two government interests in the preamble, national security, that seems like a pretty good thing, protecting us from the Chinese corporation espionage. And the other is public interest protecting Montana youth from basically smacking themselves upside the head, or other stupider things that Gen Z may do. So that's legitimate. To protect Gen Z from hurting themselves, those who can't afford rubber helmets, we might need to ban it for them. We might need to protect those kids from hurting themselves, because that's just what they do. Plaintiffs argue that the legislature's stated interest in passing 419, despite providing no affidavits or additional evidence, state contends legislature's purpose in passing 419 was merely protection of Montanans against TikTok's allegedly harmful data practices. Plaintiffs have the better argument. The court job in evaluating policy under immediate scrutiny is to determine whether the government's stated goals qualify as important or substantial. The government must demonstrate that the recited harms are real, not merely conjectural. When considering the government interest in passing a law, courts look to legislature's stated intent, which is what we're doing here. And here, if we look at their stated intent in the preamble, they're pretty clear. They say China is bad, very bad stuff coming out of China, very bad, very bad China, and Montana has an interest in gathering information about, and they're trying to find out and poke around in those Montanans, find out what those Montanans are all thinking about, and engage in espionage of Montanans. So, and they also say that TikTok doesn't remove and may even promote dangerous content that tell minors to basically shove beads up their nose. And we know that Gen Z is just too weak to figure out to ignore that. So the foreign policy purpose is not important to Montana's state interests. That doesn't make sense to us. Of course, I don't really buy that. State posits nothing precluding a state from legislating in the field of national security. The founding fathers viewed that proposition. Skeptic would probably laugh at you for saying that that's the state interest, that you're worrying about international espionage. That sounds not really very much like a state interest, more like a federal interest. During October 12th hearing, states supported the argument by analogizing to a state statute that prohibits acts of terrorism. That hypothetical law, the state argues, might have a national security element to it, but it also has domestic and state-centered reason for enactment. So this judge is very skeptical. Like, why are you worrying about Chinese espionage? Isn't that for the federal government to worry about? Like, why is the state doing that? And the analogy would be well taken given a different set of facts than here. But your terrorism analogy, banning terrorism, is secondary to the real purpose, which would be to protect people against acts of violence. So while your analogy may make sense on its face, it's inopposite. Terrorism, while it may involve a foreign actor, is not a definition of foreign concern beyond the reach of state law. In contrast, 419 explicitly bans TikTok because of direct connection to the specific foreign nation. At best, state's comparison is weak, and at worst, is reflective of the pervasive undertone of anti-Chinese sentiment. You anti-yellow bastards! That's funny. As explained in more detail, Montana does not have constitutional authority in the field of foreign affairs, so why are you even getting into this? Second, your preamble's whole child protection thing, maybe that might be state important. Remember, we're talking about intermediate scrutiny, so we say that, okay, protecting children, that sounds like it's an important state interest. You have that power, that's all well and good. But it's hard to think of a government interest more, and we have this quote here. What government interest can be more important than protecting your children? But what about the children? However, the state did not address this interest in its briefing. So the question is whether this interest is important for the purposes of First Amendment analysis. How do you not bring that up in your briefing? Oh my God. That's weird. Determination whether this interest provides an important state interest is not made here in the light of the enactment of 384, which independently provides such protections. I guess this judge thinks, okay, if you have brakes, you don't need a seatbelt. Trying to protect children. It's like, yeah, you're not really trying to protect children here. State attempts to persuade that its actual interest in passing the bill is consumer protection, but it hasn't given any evidence that that's really a problem. So I'm not buying that. And because Montana does have an important government interest in regulating foreign affairs, doesn't have an important interest, and because state hasn't demonstrated that there's real consumer protection, I think you're going to have a problem passing this intermediate scrutiny. And when it comes to tailoring, even if I give you your whole consumer protection, it's got to be narrowly tailored in the least intrusive means of establishing a desired end. So how are you going to get this end that could have been less intrusive? And it's not invalid simply because there's some imaginable alternative that might be less burdensome to speech. Rather, the requirement of narrow tailoring is satisfied so long as regulation promotes a substantial government interest that would be achieved less effectively absent the regulation. That's to say, government may not regulate expression in such a manner that a substantial portion of the burden of speech does not serve to advance the goals. It's got to be that most of what you're doing is designed to promote the goals. Okay. State claims that 419 is narrowly tailored and meets this standard because it only bans TikTok, not other social media. You can have all other social media. We could have banned everything. There's a lot of bad stuff out there for kids on social media. Could have done that. We didn't do that. In doing so, it argues 419 eliminated the exact source of evil it sought to remedy. Plaintiffs argue that 419 burdened substantially more speech than is necessary to fulfill even its purported interest because the legislature used an axe to solve its professed concerns when it should have used a constitutional scalpel. We're sitting there hacking away at our rights here when you could have done this, gotten the same and relatively the same result without banning TikTok. How? It burdens substantially more speech than necessary. And 419 completely bans TikTok in Montana. It doesn't limit the application in its targeted way with the purpose of attacking the perceived Chinese problem. At the October 12th hearing, state argued the law is narrowly tailored because the only way legislature could have stopped the purportedly improper behavior it wanted to prevent. In its brief, the state cites a March 2023 article from Reuters reporting on a group of 45 U.S. attorney generals who moved to file in Tennessee state court as an amici curiae to argue that TikTok has deceptively and improperly ignored requests to produce internal company documents in response to state investigations. They got 5 different states all sitting there making requests, and TikTok basically says, I'm not giving you nothing. So the state says, look, if we did anything less than what we did, then this all-out TikTok is banned stuff, TikTok has shown they're going to just disobey it based on how they ignored other stuff, other demands that were made by other states. But it's unclear that this single investigation this study you did is enough to warrant a complete ban. In the same legislative session, the legislature also passed AB 84, which is a data privacy law called the Montana Data Privacy Act. And that's supposedly to protect Montanans against unsafe data collection practices from social media companies in the state. So courts may not sift through all the available imagined alternative means of regulating an issue in order to determine whether the state's solution was the least intrusive means of achieving the desired end. But the state may not regulate expression in such a manner that a substantial portion of the burden on speech does not serve to advance its goals. It's got to be that when you're doing this, most of the point of the law is, most of the stuff that you're doing there is addressing the problem. Banning TikTok outright to support a factually unsupported interest is a clear example of regulation that burdens more speech than is necessary. You want to watch a debate instead, at least it might be funny. Be funnier, Joe! Be funnier! Be funnier, Joe! They don't have normal internet in Montana. Who cares about how TikTok works there? Because this is about what your lines of speech are. It is what it is. Sorry, Russian bot. Sorry. It starts in Montana. It starts in Montana. It goes elsewhere. You think it's just Montana? It starts in Montana. Also, I think it's an interesting question whether or not people want to have it banned. So far, my poll is 63%. Should states be allowed to ban TikTok? Most of you think yes. 2/3 of you almost think that they should be allowed to ban it, which I'm surprised. I thought it would actually be flipped. I thought it would be like 63-37 no. You want to give that power to the state? I'm surprised that 63% of you said yes. Really? Really surprised. So there you go. And the other problem that the court has is there's no evidence that it's actually going to alleviate the harms in a direct way. Because other social media companies like Meta also collect data, sell data, which harms them. So you're also worried about their data being collected. You're not worrying about the other companies that are collecting them. Many ways a foreign adversary like China could gather that from Montana without using TikTok. They can purchase it from other data brokers like Meta. Ooh. That's a fair point the court's making. It's a fair point. So it's not really clear that it's going to alleviate the potential harm Montanans being exposed to China. And although the state doesn't explore this argument in detail in its briefing, it doesn't reasonably prevent minors from accessing dangerous content on the internet. It's not hard to imagine how a minor may access dangerous content on the internet. There's no end of dangerous content on the internet. So if they don't get it from TikTok, they'll get it from elsewhere. You're not really doing anything. It's like basically you're blocking this one door while there's a whole flood of water that's coming in here. So it doesn't seem like that's really doing anything. This part of what the judge is saying, I agree with. I agree with him on this. This is logical. This raises serious doubts about whether the government is in fact pursuing consumer protection interests. And the state concedes that the ban is not a blanket prohibition on creating, sharing, and viewing videos on every internet-based application. So, yeah, what the hell are you even doing? And ultimately, Montana's interest in consumer protection is in protecting is going to come through legislation, what you did here wasn't narrowly tailored. So you lose on that. And then even if we assume that the state did narrowly tailor, you still failed to pass intermediate scrutiny because it doesn't leave open other ample alternative channels of communication. I don't really care about this point of this. This part of this, I don't care. So ultimately, this analysis does not impede the state from acting as a leader and attempting to protect its residents from harm. But to do so, it has to act within the constitutional legal context which the legislation belongs. And 419 bans TikTok outright. In doing so, it limits their constitutional protection. Ban TikTok, see how quickly our First Amendment rights follow. I mentioned this to you on a call at the beginning of the year. Wake up, sheeple. Yeah, I agree with. The more I've watched in this, the more I think we should not allow the banning of TikTok. I would ban China from owning property in our country, but information is a free flow of information. That's reality. You can buy from anywhere. So, federal preemption, constitutional laws of the United States and the supreme law of the land. Judges of every state are bound thereby anything in the Constitution. And the Supremacy Clause of the United States says that the law may be preempted by federal law. Preemption may occur when a state law infringes on the federal government's exclusivity over foreign affairs. So we have the federal government has basically preemption argument is basically the who's overseeing our foreign affairs? That's the federal government. Why is the state of Montana doing this? It's a good question. So plaintiffs say that you're preempting federal law when you start trying. You're safeguarding Montanans more than the federal government's doing. The state disagrees. Both parties have merit, but ultimately, since they demonstrate a likelihood of foreign affairs field preemption, at least one instance of conflict preemption, 419 is most likely preempted by federal law. Okay. Constitution says foreign policy is only for the national government, not for states too. And that no less that our system of government is such that the interests of the cities, counties, states, no less than the interests of the people of the world nation imperatively requires federal power in the field affecting foreign relations be left entirely free from local interference. This is kind of like the whole thing as far as states talking about, this is why I don't like what George is doing with its trial of Trump. It's like, this is a federal election. You're sitting here. He's trying to oversee a federal election, and you're sitting here weighing in about what he's doing in Michigan. It's retarded. So too, why is Montana trying to be the ones to stop China? That's for the U.S. to do. Doesn't seem like that's a Montanan thing to do. Although rarely invoked, the foreign affairs field preemption doctrine straddles both the conflict preemption and field preemption doctrines. Under foreign affairs field prevention, a district court must prevent the state law from taking effect when it has no serious claim to be addressing a traditional state responsibility. Why are you worrying about that? This is the field preemption. So you have no jurisdiction to be worrying about this. And two, when it intrudes on the federal government's foreign affairs power. So the plaintiffs say that this preemptive doctrine invalidates 419. The state says, we're not really getting in their way, so everything's fine. This is not an argument you hear very often about the power of the state or the right of the state to pass laws that really should be handled by the federal government. So the state first argues that 419 is not aimed at creating a forum for suing China or regulating international matters. It's just a consumer protection law. Plaintiffs say that the main purpose of 419 is to make a foreign affairs statement that we don't like you, China. You stink, China. China's bad. China, boo. We hate China. We hate China. Plaintiffs say that, and after considering the text and legislative history of 419, it's pretty fair to say that this is not your classic consumer protection issue. And I think that the plaintiffs are right. This is about China, you stink. And courts have consistently struck down state laws, which are really area of federal foreign affairs. And it cites this case of Von Sayer versus Norton Simon Museum of Art. So when the state ex post facto, meaning after the fact, they come along and they say that they're claiming it was all about consumer protection. The language of the statute and political context in which it was enacted do not support that conclusion. So I'm rejecting that argument there. And you look at the text of the bill's operative language, courts have to look further to determine the real purpose of the state law, not just what you put in writing. Because China exerts control of TikTok and gain access to Montanans' data without their consent, but the state doesn't give evidence for that the Chinese government is controlling ByteDance. You have speculation, lots of reasons for you saying, oh, we think China is here. Yeah, maybe you're right. You don't really give too much in the way of evidence. News coverage is contradicted by sworn affidavits from TikTok. So how do we know that these news people know what the hell they're talking about? Maybe they don't. You're fake news. You're fake news. We don't know. Could be. Long Black Train says this is not about freedom of speech. We can't have our apps in China, so they should not allow to have their apps here in the U.S. Well, that's a federal issue. That shouldn't be for Montana. You might be right. That should be a federal issue, though. Right? So the court basically says after we look at the real purpose of the law, and the foreign affair purpose becomes even more clear. Because it says TikTok gathers significant information from its users against their will to share it with China. And Montana serves as a valuable tool to China. Montana is not uniquely valuable to China. Trust me, New York's a lot more valuable. California is a lot more valuable to China than Montana. And like what trees are growing in nicely this year. And trust me, I have far greater respect for Montanans than I have for people living on the coast. They tend to be far more salt of the earth kind of folks. When you talk about the financial benefits and the having influence, I'm fairly certain that China cares a lot more about New York folks, Californian folks, Floridians. They care about dense populations. So for all these reasons, he thinks that the preemption law is a little bit of a problem here, because it seems pretty clear that this is all about Montana going to war with China, and we're not really sure why it is that's really the state of Montana's place. It goes to the second reading of the bill, where they basically talk about how he was all about China. Representative Brandon Lur was basically saying, hey, we're facing a threat unlike any other from Chinese Communist Party hiding behind TikTok. That sounds like a federal issue. A Democrat from Missoula noted TikTok's perhaps dangerous, but the bill is not taking privacy and security seriously because it only limits one company and only one country. And they had this whole back and forth between them. So to this judge, I think it's a fair read that this is really about stopping China, which is a little weird. Like it's in legally tenuous ground to say that a state is going to be dealing with is going to set the way for how we deal with China. Then you have intrusion of federal foreign affairs power, whether it intrudes on a power expressly or impliedly reserved for the federal government. And then choose on the federal government's exclusive power to conduct and regulate foreign affairs. This sounds eerily similar to the argument we just addressed. It expresses distinct political point of view on a specific matter of foreign policy. That a California statute that imposed a politically charged label of genocide on the actions of the Ottoman Empire was making a political statement. So 419 attempts to establish a foreign policy for Montana. And as we explained above, not really sure where Montana, the state of Montana, thinks it has that authority. And that intrusion's effect on foreign affairs. So you're kind of stepping on the federal government when you start weighing in as to how you feel about China. Next, you'll be weighing in on Malaysia. You'll be weighing in on France. And we're not going to have 50 states weighing in about how they feel about every country on the globe, because that could cause problems. I think that's a fair point. State finally argues that 419 is non-intrusive because it fits within the federal government's foreign policy, as it merely restates. We were agreeing with the foreign government and labeling China as a foreign adversary. So how is that a problem? The state asks. But even if the absence of conflicting federal policy, you can still violate the Constitution by establishing its own foreign policy. Okay. You don't have a right to have any foreign policy and say our foreign policy is consistent with federal government. So why do you have a foreign policy at all? Conflict preemption. See, I'm scooting through this. We're scooting through. When Congress enacts a valid statute pursuant to Article 1 powers, state laws naturally preempt to the extent of any conflict with federal statute. Okay. The plaintiff says that Section 721 Defense Production Act directly conflicts with 409. Only the former argument is persuasive. The Defense Production Act. Plaintiff argues the Defense Production Act conflicts with 419 because TikTok's parent company ByteDance are currently engaged in negotiations under the law. Would you have supported MT popping the balloon? Who's MT? Margaret Thatcher? Mr. T? Marjorie Taylor? I don't know what you're talking about, brother. Montana? Popping the balloon? That's a good question. That's an interesting question. If they pop the balloon. Well, do you know that it's coming from a foreign place? That's a good question. I don't think they should. I think that is a federal issue. We see the same thing happening, by the way, with respect to Texas, Arizona, how they deal with the border crisis. They're like, hell with you, federal government, you suck. And this has become a crisis for us. So the state claims that plaintiffs have not identified a specific transaction covered by the Defense Production Act. So you haven't shown a conflict. That might have some merit, but doesn't overcome the demonstration of a likelihood of preemption. All right. I'm not really interested in the whole preemption question. I don't know why, but this doesn't do anything for me. Economic Powers Act. State argues that because SB 419 regulates a product, does not impose any regulation on China itself. The Economic Powers Act does not preempt it. Plaintiffs say that 419 squarely upsets the balance struck by the Economic Powers Act, which gives the president peacetime authority to deal with any unusual and extraordinary threat, which has its source in whole or in substantial part outside the United States to national security. So this is similar to the whole federal powers issue. He's basically saying the president is the one who should be handling this. And so the plaintiffs can see that TikTok regulates personal communications, cannot be regulated under the Economic Powers Act. However, they also argue that because this act cannot regulate this activity, neither can Montana. So they're basically saying no one has a right to regulate this. Conflict preemption exists when it's impossible for a private party to comply with both state and federal law. It's unclear how a party could have trouble complying with both the state and federal law when the federal law itself cannot regulate a conduct of issue. So I'm not sure what the plaintiffs are talking about there. That's basically what the court's saying. It's like, I don't know how, when you're saying that they have no right to do it here, but we have a problem because we can't comply with either one of them, that doesn't make much sense. That doesn't make any sense at all. Meaning the plaintiffs is saying, well, the federal government has no authority over us in this particular area, and the state law is putting us in a problem because it's conflicting with the federal law. What? You just said the federal law has no governing weight over you. How you can have your cake and eat it too? Commerce clause. Those many of you may be wondering, what is the Commerce Clause? What is the Commerce Clause? Commerce Clause is one of the primary bases for where federal Congress has authority. We're talking about international commerce. It gives Congress power to regulate commerce with foreign nations and among the several states, meaning between the states. Plaintiffs argue that 419 violates the Commerce Clause because it regulates the platform Montanans use to conduct worldwide commercial activity. They also argue the Commerce Clause is violated because 419 facially discriminates against a foreign nation, China, in commerce. In countering, the states argue that 419 permissibly legislates purely intrastate issues with a minor burden on interstate commerce. But I agree with the court agrees with the plaintiffs that there's a dormant Commerce Clause which says that even though the clause is put forward as a positive grant of power of Congress, still, meaning that when it comes to passing laws that's going to affect Congress, that's going to affect interstate. There's a further negative command, which is known as the dormant Commerce Clause. You can't say this is how things are going to work between our states. There's also something called a dormant Commerce Clause, which says that it prohibits certain taxation even when Congress has failed to legislate on the subject. Meaning, let's say Congress said nothing about this. They haven't said anything about this. There's a dormant Commerce Clause that even though they remain silent, you can't just step in there and say, we're going to start handling this. That's called the dormant. That's like the silently laying dragon. And even though the dragon hasn't weighed in on this, that doesn't give you authority to come in here. The clause provides that in all but its narrowest circumstances, state laws violate the Commerce Clause if they mandate differential treatment of in-state and out-of-state economic interests that benefit the former and burdens the latter. Of course, the parties agree that 419 regulates interstate commerce. The relevant question here is whether the burden imposed on such commerce is clearly excessive in relation to the putative local benefits. So obviously the plaintiffs say the burden exceeds the benefit and the state says it doesn't. It's so discretionary, it's helpful to consider how courts have previously considered similar issues. And he looks at Bibb versus Navajo Freight Lines, where the Supreme Court declared unconstitutional state law which required all trucks passing through a state to use a specific type of mud flap. So if you're driving through our state, you can't drive through here unless you have this mud flap. What the hell are truckers supposed to do with that? They're supposed to start slapping mud flaps on as soon as they drive through your stinking state? The Supreme Court reasoned that because all but 5 other states allowed the regulated type of mud flaps, trucks would need to avoid the state or swap out their mud flaps upon entry. That burden on interstate commerce did not exceed the local benefits of which the court found few. There's no benefit. There's not sufficient benefit to you. So you're really putting a burden on interstate commerce over here also. You're burdening user plaintiffs by prohibiting them from conducting business on the app. And it's also burdening TikTok by requiring the company to completely change its business to operate in Montana by selling an owner based in a non-adversarial country. And while the state says that the law's local benefits are significant, and they may be, it's not providing any evidentiary support for those benefits. So the plaintiffs demonstrated that they're probably going to win on this interstate commerce clause as well. And also, there's a facial discrimination, meaning that they don't like the faces of certain races, so they're discriminating against them. Totally was joking with that last line. See if you're paying attention. People still believe those balloons were Chinese. What do you think they were? I was cheap with the character limit. My apologies. What do you think they were, Barracuda? What the hell were those balloons? I don't know what the story with those balloons were. I never understood the balloon situation. I missed this a long time ago. Most Band Queen says, I think it's funny that Facebook started the conversation about why TikTok should be banned. Nate did a video on it. It made me wonder how much of our fear of TikTok has been manipulated by Zuck. Zuck the schmuck. I never thought about that. I didn't see that video. You don't have to apologize. You were trying to confuse me, so I'd sit here going MT. So facial discrimination, that plaintiffs argue that 419 violates the Commerce Clause by facially discriminating against commerce with China. State does not substantively rebut this argument. 419 becomes void if TikTok is acquired by any company that's not part of China. So they kind of recognize that. And state plainly admits that it's banned TikTok because of the harms. And they say facial discrimination, TikTok argues, per se invalidates a law. And the court agrees. So the state is like, we don't think that invalidates the law. The court says, no, it does. I agree with the plaintiffs on that. So there you go. It looks like you're discriminating against China. And you are. I think that makes it illegal. Irreparable harm. This seems like it's like a little bit repetitive at this point. So remember we said there are 4 elements you have to have. So one is likelihood of success in the merits. The first 45 out of 48 pages were basically trying to show why he thinks they're going to win. Page 46, we get to irreparable. So the next step is irreparable harm. After you get likelihood of success in the merits, you have to establish your likelihood to suffer irreparable harm, which means harm that cannot be compensated for with money. And when you talk about First Amendment issues, that's always going to be irreparable harm. So we're good there. We don't have to worry about that, because how do you ever compensate someone for damages that they were limited in their ability to speak? You can't. So whenever you're talking about limiting someone's ability to speech or practice their religion or peacefully protest, peaceably assemble, that's going to be irreparable harm. So once they got likelihood of success, they got irreparable injury, and shutting off TikTok, you harm the user, plaintiff's First Amendment rights, and cut a stream of income, which they may rely. And that's another thing. It would be hard to establish how much income they lost. So that also could make it irreparable harm. Next question is public balance of equities and public interest. When the government's party courts merge the balance of equities and public interest factors. So, because government's always dealing with public interest, that's why they exist. So Ninth Circuit has gone so far as to hold the plaintiffs have raised serious First Amendment questions, compels a finding the balance of hardships tips sharply in plaintiffs' favor. So therefore, I'm giving them, as demonstrated above, 419 violates the Constitution in more ways than one. Thus, what? We lost the rest of it? Thus, for all the foregoing reasons, I'm granting them their injunction. And this law is not going into effect. There's one last thing I wanted to watch with you before. I promised you something funny before you go. Closing out the weekend. Tomorrow, I plan on being laid back news with my good friend there, Eric Hunley, and whatever attorney friends he gives me to play with and hang out with. You'll know what time I show up there based on when I send a notification on goodlawgic.locals.com. And not that. This is what I wanted to share with you. I was watching this. So this is something actually I found on TikTok, which this group is called Impractical Jokers. And I was like, this is pretty funny. This is pretty funny. And I think you guys would appreciate this. I didn't finish watching it, but I thought it was funny. These guys are pretty funny. Basically, it's a bunch of guys who one of them keeps an earpiece in their ear. Like they take turns as to who is the sucker that has to basically go through with something. And they're basically asked to pull a prank or something of that effect. And while they're pulling the prank, they're being watched on video and being directed, and they're obligated to follow whatever direction they get, no matter how embarrassing it is. It's a pretty clever it's pretty interesting concept. And this one just popped into my feed right before I came on air, and I got like 2 minutes into it, and I was like, oh, I want to watch the rest of this, so I'm going to. Chinese have roughly 600 satellites in orbit. In June this year, they launched 41 in a single day. Precision to 1 centimeter on the ground. Why would they need a 250-year-old tech to spy on us? That's a fair point. That's a fair point. All right. So this is Impractical Jokers. I thought this was pretty funny. At least the first minute and a half I saw of it.
Uncommon to hear the phrase, "That's a man's job." And I want to hear your thoughts on that particular phrase.
So remember, just oppose their views. It's super simple.
Brian?
There are men's jobs and there are women's jobs. I mean, I think we all.
He's sitting there on a panel discussing with a bunch of feminists.
But we're not saying that doesn't exist, right? I mean, you're not.
We are kind of saying that.
But it's just like if you pull up to a garage and you got to get like an alternator replaced, and there's a woman mechanic. The majority of men and.
Do you see that orca there? Look at that orca. Look at her. She's like, where are you going with this? Where are you going with this one, boy? About the mechanics. I'm a mechanic. I'm a damn good mechanic. She's either saying that or she's going, one of those things, what she's saying.
Mechanic. The majority of men and women are going to look at that and be like, hey, man, I'm all for, women's rights. I mean, who isn't? But I also want my car to run well.
You can feel it. You can feel it. I can't take it.
That's funny. Oh, that was funny.
We're going to discuss some of the most influential women, who you think they are, and sort of what gives them that influence. Michelle Obama, Shonda Rhimes. Women can do all sorts of things.
We can do all sorts of things. Women are magical. Magic is the spirit of illusion, and illusions can be magical. Thank you.
All right, buddy. Now disagree with that.
These are, the Michelle Obama thing. She got there because she slept with a man.
Oh my God. Oh my God.
I think Michelle Obama is a fantastic example.
Right, but she wouldn't be in the White House if her husband hadn't gotten her there. I mean, very pretty. Very pretty.
Very pretty.
I don't know how much I can take now.
Brian, actually, this next question is for you specifically. You have a blog entitled Brother of the Sisterhood, and a recent excerpt from your blog reads,
This is Q's quote that we wrote.
"If women made as much money as men, they would definitely spend it all." Specifically for their children, because they are such loving human beings by nature. Often cloud their judgment, though, making them unstable or irrational. Can you please explain that quote?
Oh my God.
I think that's true of everybody. Maybe I didn't make that clear enough. I've made
He's backing out.
a lot of irrational decisions. I've chosen bad friends. So I think the point I was trying to make there was just like, hey, these ladies, they're going through a lot.
Brian, do you have any closing remarks?
If I had boobs, I'd play with them all day.
He just heard what he has to say. That's pretty funny.
This is it, and you're all done.
Are you sure you don't want to make closing remarks before I go? I guess my closing remark is,
Can't wait till you say it. Oh my God.
if I had boobs, I'd just be home playing with them all day. So the fact that you're not is amazing.
That's pretty funny. That's pretty funny. So there you go. I recommend that channel. Check them out. I'm wrapping up here. And I will see you all, God willing, on Saturday night. Thank you for joining me. Hope you enjoyed. And I will catch you then, or layback news of goodlogic.locals.com. 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 Say it. Say it with me. Say it. Say it right now with me. goodlogic.locals.com. You got it. Salute. Be happy. Eat some bugs. Godspeed.